Okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you?
My personal security, which I'm entitled to rights to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it.
Mr. Arnold, I ruled against you. I am allowed to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system.
Okay, one last time. Now listen. Here's how it's going to go from this point on. If you don't answer the question that I asked specifically, then I'm going to hold you in contempt of court.
I'm living in the private. I'm driving in the private, and so I want to move for dismissal with extreme prejudice. You remove this case because this is double jeopardy. I already appeared in court for this thing. I have not been given the opportunity to explain myself. I want to keep my rights, and I haven't been able to keep my rights.
All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks, and it's more of a accuracy of the actual accounting that I'm trying to make sure, and, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, I mean, back on 5/15/23, you owed $3,398.36, and they're coming for $3,398.36. I mean, that was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I I am the lender, and they borrowed from me.
What did they borrow from you?
My personal security, which I'm
No,
entitled to rights to.
no, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. This. I'm going by the law, Your Honor. I'm not just making up
No,
anything.
you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card, and you didn't pay on the card. They don't owe you anything.
So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. One second here. I have them.
No, wait a minute. December 19th.
Okay. It's going to have to be January 9th.
Okay.
My clerk's indicating. So
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set. All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and it was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for the inconvenience. So that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. I'm setting a date. So what do we need discovery on this? Mr. Goethals, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you, Mr. Arnold. Mr. Arnold, I have ruled against you. I am allowed to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
On James Garner, do you see all the cases he has?
I see just the 4 that are on the docket, or 5.
Yeah.
You've got more?
He's got plenty more.
Okay.
Mr. Garner, do you want to offer on these, or do you want to go to trial?
I would like to know what the charges are.
Okay, this is the city of Detroit versus James Earl Garner. Case number SP 11000435, counts 1, 2, and 3. SP 11695. Those are driving license expired, misdemeanor, no insurance, insurance misdemeanor. Thank you. And an improper plate misdemeanor. All of them punishable by maximum possible penalty of 93 days in jail and or $500 in fines. SP 1169507, counts 1 and counts 2, expired license and no insurance misdemeanor, both punishable by 93 days in jail and or $500 in fines. SP 1169521, same improper plates, same punishment, $500 and 93 days in jail and or $500 in fines, maximum possible penalty. SP 1223079, driver license suspended. SP 1273761, SP 1927512. 3 of those tickets are drive, all punishable by 93 days in jail and or $500 in fines. SB 1547006 counts 1, counts 2, and counts 3. Those are civil infractions. SB 1547407 counts 1 and counts 2. Count 1 being a driving while license suspended repeat offender. This one is in warrant status, probably an old case that he didn't pay. SB 800104 counts 1 and counts 2. 1 being an unregistered untitled. He owes $1,194 on that. And SP and count 2 of that is a drove while license improper. It looks like he has a $114 fine on that. State of Michigan versus James Earl Garner, case number SX 36268561. That is a drove while license expired. And that will be $500 maximum possible penalty, 93 days in jail and or $500 in fines. Appearance for the record, please.
Sherika Harris on behalf of Mr. Garner. Mr. Garner, please state your name for the record.
First off, I do have a couple.
You got to state your name first. You got to state your name first.
No,
Let's start there.
I think, wait a minute, Ms. Harris. Wait a minute, Ms. Harris. I think Mr. Garner is going to represent himself. Am I correct, Mr. Garner?
I'm representing myself in what? I mean, I'm confused about what's actually going on. First off, who's alleging these charges? That's what I'm curious about.
State of Michigan, City of Detroit.
Okay, well, if that's the case, there's a common law principle which states that for there to be a crime, there must be a victim. Corpus delicti. The state cannot be the injured party. And in the absence of a victim, there can be no crime.
Withdrawing my name from the record on that one. Thank you.
I know. How do you want to proceed, Mr. Garner? You set the matter. I'll enter a not guilty plea on his behalf. Give him a $0 bond. Either set the matter for trial, or I'll wait for the city to give you an offer. What do you want to do?
Well, the court hasn't even established jurisdiction. I mean, in order for jurisdiction, the jurisdiction has to be established first, and there's no jurisdiction established. And once jurisdiction is challenged, that must be settled before charges can be brought.
All right. Do you want to put that in a motion, sir?
As far as I'm concerned, any and all charges must be dismissed because there is no complaining witness, and the state cannot be.
I'm not gonna listen. If that's your motion, I'm gonna deny the motion. Okay. So all we're gonna do now, we're not gonna keep going back and forth. Either you take an offer or you set the matter for trial. Which one do you want?
Respectfully, in order for this to continue, there must be a complaining witness, and the state cannot be a complaining witness. Now, if I'm entitled to a fair trial, the law states there must be a victim. I'm just requesting, who is the victim? Who did I injure?
The citizens of the city of Detroit and the state of Michigan are the victims.
The state cannot be a victim. And if that's the case,
I said the citizens of the city of Detroit and the state of Michigan are the victims.
If that's the case,
Mr. Garner, can we just go into a breakout room and then maybe I can give you a little bit of advice to assist you with moving forward? Would you be agreeable to that?
Sure.
Okay, awesome.
Join. All right, are we ready on Garner?
I believe he's ready, Your Honor. He's representing himself.
Let's go back on the record with Garner. What do you want to do, Mr. Garner? Do you want a trial date or you want an offer? Those are really your only two options.
Okay, since we are on the record, all I'm asking for is the
Okay, one last time. Now listen, here's how it's gonna go from this point on. If you don't answer the question that I asked specifically, then I'm gonna hold you in contempt of court, and we're gonna move from that point on, right? Get up, Mr. Raymond.
So you're telling me,
Mr. Garner. We're not gonna have a conversation. Stop, sir. Stop, sir. Now, that's the last time I'm gonna ask you to speak
on the law. Is that what I'm hearing?
All right.
I'm asking.
I'm gonna hold Mr. Garner in contempt of court. He is directly violating the court's order. I've asked him repeatedly to not interfere or add any extra commentary to this case. I've given him ample time to answer the court's question, and he continues to refuse to do so. So now I'm going to hold you in contempt, and I'm going to sentence you to 30 days Wayne County Jail, no early release.
So that means that the court is just going to violate my rights because I'm defending myself? Is that what I'm hearing?
30 days, Wayne County Jail, no early release. That'll give you some chance and some time to read up on your rights, okay? Fill out the contempt papers, Madam. So I'm gonna order you to turn yourself in today, Mr. Garner, to start that jail time, okay?
So I have a question.
I'm not answering any more of your questions. Turn yourself in to the Wayne County Jail today.
So the court is going to be in direct violation of my rights in the law. Is that where we're standing?
That's how you feel. Have a good day, sir.
We are on the record in 2024 TR 617. Sir, you may need to scoot over a little bit to be picked up by that microphone. I'm not sure, but sometimes you have to be in the middle with it. Mary Ann Shirley appears for the state. Are you Abel Estrada Jr., sir?
Yes, if I may, can I make a statement?
No, not yet. Okay, sir, you are charged in count 1 with on or about the 21st day of August, 2024 in Greenwood County, state of Kansas. Then and there, contrary to the statutes of the state of Kansas, unlawfully operating a vehicle, to wit, a 2011 GMC Acadia, upon a highway which does not have the signed license plate. I think they mean that the vehicle didn't, not the highway, but your vehicle did not have the assigned license plate properly affixed to the rear of the vehicle, showing the current registered year. And this is an unclassified misdemeanor. It is punishable by up to $2,500 in fines and a possible sentence of up to 6 months, 30 days minimum, up to 6 months, although probation is usually granted. Now, sir, did I not just have you in municipal court recently on the same charge?
Yes, and I don't understand why am I seen again, because that would be double jeopardy. I'm saying for the same.
Sir, you haven't been tried on it. You
I have
had a first appearance on it. And
I have,
apparently the city prosecutor must have dismissed it and refiled it over here for whatever reason, I know not. But as I recall, your plea was not guilty. Is that still your plea?
yes, but I'm here to make a separation between my name. My name is Abel Estrada with low caps. This name on the top, I don't know if you can see it. This name on the top is my straw man. I am the man, and this is the straw man. So if you're calling the straw man, I'm here to represent the straw man, but I'm Abel Estrada Jr., the man. the living man.
I'm calling the living man.
So
All right, so are you going to have an attorney? Are you going to need to apply for court-appointed attorney, or will you be waiving your right and representing yourself?
no, of course, I wanted to have an attorney, but I still haven't not made my statement, which is,
Are you going to hire an attorney or apply for court-appointed?
I cannot afford an attorney, but I need to make my statement that
Let me get a few things worked out, sir. You're going to apply for an attorney, so you'll need to fill out an application for court-appointed attorney. And the deputy down there can give that to you. Make sure you fill that out and get that back to me before this hearing is over. Make sure you fill in all the blanks and you sign it and you date it where it says to, because I generally don't consider those if they're not thoroughly completed. And then you call back to my assistant, Missy, later in the week to see if one is appointed and who that will be. Do you need Missy's number, or did you take it down earlier from the other hearings?
no, I don't have.
All right. Missy, do you want to give him your number?
620-583-8155.
And then Missy, when is his next court date?
Well, I haven't explained my position.
Sir, we're not going to have a trial today. You're going to need to talk to your attorney before you have a trial. So Missy, when is his trial date?
I wanted to move.
Sir, please do not interrupt. Missy, when is his, and we won't set it directly for, do you want to set it directly for trial, or do you want to set it for a status so I can check in with you after you talk to your attorney?
I don't know what the status means.
Well, let's set it for a status, Missy, or control.
November 22nd at 10.
You, sir, will need to be back here by Zoom November 22nd at 10 a.m. Are you on bond? Let me check.
Why would I need a bond?
Complaint from the cause. There is no bond on the file, and it is an unclassified misdemeanor. So I'm not going to make you file a bond since it's an unclassified misdemeanor. If you fail to come to court, though, most likely a warrant would be issued anyway, and you'd be taken into custody. But as long as you come to court when you're told to, that's not going to be a problem. So you're going to call and get your attorney, or find out if you have an attorney.
I haven't given a chance to
you do not need a bond, and you have your court dates.
Number one, I want to move to a motion to dismiss this case because I didn't try for this, and I have the license plates, both license plates. I was not driving anything unlawful or illegal. I'm living in the private. I'm driving in the private, and so I want to move for dismissal with extreme prejudice. And also, I want to make sure that you understand that I want to keep all my constitutional rights. So far, my constitutional rights are being trampled over right now by yourself because you're not giving the chance to speak. I have not given the chance to speak. You're just going over and over, and I'm requesting that you remove this case because this is double jeopardy. I already appeared in court for this thing. I have not been given the opportunity to explain myself. I want to keep my rights, and I haven't been able to keep my rights. You yourself and the lady on the other side signed a oath of office to uphold the Constitution of the United States, and I'm not being given those rights right now, man. I respectfully request that you honor my rights. And I want to move for a complete dismissal because it's double jeopardy and I already appeared in court.
All right. Well, I did give you the opportunity to speak. You were speaking, not I, not Miss Shirley. And so I gave you the chance to say what you want to. If you want to talk to your attorney can help you put together the motions that you've kind of implied, at least, if not outright said, you want to pursue. But we will take that up on the date that I gave you to reappear.
I'm sorry, I didn't, it's breaking up. You said you're going to take what up to do what?
I can take up any motions that you want to file at a later date. With the next court date, we can revisit any motions or visit any motions you want me to consider.
I appreciate it. Thank you.
You're welcome.
Being dragged on so much, and I have a hard time moving around. As you can see, I'm disabled, and I only come here once a week to the hospital to be treated, and all this court is putting a lot of stress, and I'm not able to heal properly. Why are we dragging it out so much, ma'am?
When did you get this disability? I don't remember you being unable to walk the last time I saw you.
I came in my bike is right here. I have it right here. I don't know if you can see it. But I normally use a walker in a wheelchair, but I'm using the other one because it's easier to carry in the car. It's what's it called? It's knee scooter. I have 2 amputations on my feet. So ambulation is very difficult. I'm having a lot of pain. In fact, I'm under medication right now. I don't have a clear mind, just so I can be here because it's too painful.
Well, that's why you need to call back here. You don't have to come in person. Call back here or have your wife or helper, whoever that is with you, call for you, and Missy can tell you if you qualify for an attorney and who that attorney will be and how you can get a hold of that attorney before your next court hearing. We did give you the date of that court hearing. You will need to be back here for that, but you can do that by Zoom. You don't have to even leave your home to do that as long as you've got a clear signal that allows us to communicate. So you're always welcome to come down there to the courthouse like you're doing now, but you don't have to as long as you can communicate by Zoom. And remind me, what town do you live in, sir? Are you from Kansas?
Yes, I'm in Howard. But even last night, when I got the letter from the sheriff, they brought it to me at 5 o'clock last night. I didn't even know.
All right. Well,
so it wasn't improperly served. I got it like literally last night. I'm trying to get paperwork come in, and I don't have the time. I don't have the ability to move that fast. And so
you were just complaining a moment ago that this case wasn't moving fast enough, that we were dragging it out. So there you go.
Then
move it too fast, you say.
Yes, but it's dragging on because it should be dismissed.
Judge, I need to withdraw from this case.
Your Honor, Mr. Estrada filed pro se, I do believe. Well, I know it was pro se filing.
Well, I do notice he's taken a number of filings in his own right without going through counsel. Mr. Estrada, you come back to my recollection, we've met in city court, correct?
Yes.
And now this is that tag and suspended license?
No.
No,
just a tag issue, Your Honor.
Just the tag, Your Honor.
All right.
I believe Mr. Paul is requesting to withdraw based upon the essentially sovereign type citizen claim filed by Mr. Abel.
Well,
Mr. Estrada, excuse me.
And also there's been a total breakdown in communications, Judge. He files his own motions. I cannot represent him.
He's okay. All right, Mr. Estrada, you were appointed an attorney. Apparently at one point you wanted one, or maybe we gave you one and you didn't want one.
No, that's not it.
Excuse me?
I'm sorry, that's not it. He's not, Richard Paul is not seeking my interest, and I put everything in the affidavit. He's not representing me. He's actually judging me before, just judging me before I even go into court. He's not listening to my paperwork, so he decided he doesn't want to represent me. So I still need to be represented.
Well, Mr. Paul, you're allowed to withdraw.
Thank you.
You're welcome. Is this the last case you have on the docket?
Until 11, Judge. I have an 11, so I'm just going to mute myself and.
That'd be fine. All right. Now, I think you are going to have the same problem with any other attorney that you had with Mr. Paul. Mr. Paul, from this court's experience over the years, is a very competent, diligent attorney. Now, sometimes attorneys have to tell you their opinion of what's going to happen. And you may or may not agree with their opinion, but you do still want an attorney.
I do. I do need an attorney because I don't know how to defend myself with this court. And also, I have a thread of the communications that you can see it. And I'm not getting represented correctly. I'm sure he's a competent attorney, but I proceeded to give all my information, all my laws, and he
All
doesn't.
of your what? Your laws?
The laws, the Constitution.
Your Honor,
So,
Your Honor, could I say something, please? Mr. Estrada, every attorney who the court can appoint to represent you, one, I don't want to see, and I'm sure the judge is the same way, I don't want to see any kind of communication thread between yourself and Mr. Paul, because there could be confidential, well, I'm sure there's confidential and privileged information within that, and you shouldn't be disclosing that to me. That's between you and any attorney you so choose to have represent you. But I believe most attorneys, or all attorneys that the court has available to appoint to you, they are sworn to uphold the Constitution of the United States and the state of Kansas, and not what you filed. That's the attorneys didn't go to your law school, which is kind of what you've set forth. So that's the issue the court's talking about when you're claiming a sovereign citizen. We don't have an attorney who's, I guess, registered to under your.
Psychologist Leon Festinger discovered that people experience mental stress when reality conflicts with strongly held beliefs. The more evidence pushes back, the more a person may double down instead of adjust. That's the danger here. The defendant is treating legal arguments like personal truths, but courtrooms operate on recognized procedure, not individual interpretation. Once someone rejects that difference, every attorney, warning, and ruling starts looking illegitimate to them.
Rules and laws as you see them. So that's the problem you're going to be running into as far as the attorneys the court has to appoint to you. I said that correctly, Your Honor.
thank you, Mr. Dean.
I like to say that I'm not a sovereign citizen. I'm just an American, and I'm just being constitutional, and I'm not doing anything. I'm not breaking any law.
Well, sir, you said the attorney wouldn't accept your laws or follow your laws.
No, that's not what I said. I said that,
what did you say? Because I thought you said you were trying to train him on the laws, in essence.
No, I don't. I'm just presenting the law to him, and he doesn't even read my documents that I presented, which is the law.
Did you go to law school?
No, ma'am.
He did. You know that.
Yes, I understand, but he's not being constitutional. That's what I'm saying.
But you didn't go to law school, so are you sure you know what being constitutional involves? I mean, we all can read the Constitution and understand, yes, but there's a lot involved in interpreting that. Do you understand?
I understand what you're saying, ma'am. All I'm saying is that he's using case law, not constitutional law. And he didn't see all my paperwork. He just ignored it. He just blew through it and then gave me the wrong dates. I presented all the documents, and he didn't even look at it and ignored the paperwork.
All right. And let me ask you this. You are wanting a trial on this illegal display of a license plate or failure to display, right?
Well, no, I like to address. I'd like to first, if we possibly, we can a motion to dismiss with extreme prejudice.
We're not going to do that today. All right, I am going to one more time appoint you an attorney.
Your Honor, I would, Can I make a request to the court on this matter?
Sure.
This case carries a maximum sentence of 30 days. Doesn't even have an eligibility or requirement that he be provided an attorney.
Well,
I'm just
there's
just
potential jail
saying,
time.
I would like to have if the court wants. I understand if the court wants to appoint an attorney. Absolutely, don't dispute that. But under the circumstance of the defense that's wanting to be presented, I would ask the court to appoint somebody. I get Mr. McClendon still available.
That's just what I was thinking. He's here in town.
We set this next hearing, give sufficient time, perhaps 60 days, perhaps longer, and we just have it set for a bench trial. And if he doesn't want to cooperate with that attorney, the state would be asking for the court to proceed to trial, whether or not he can get along with the second one or not.
Well, it seems we're on the same page of thinking, counsel.
Mr. McClendon is in the waiting room.
Mr. McClendon.
I can bring him in.
Bring him in. You're in Howard. He's got an office here in Eureka.
Mr. Estrada believes in Wichita.
I thought didn't you tell me you were in Howard?
I'm in Howard.
No, my mistake. I might have been on one of the notary stamps.
Well, you let Kit Collins in. Does Kit Collins want an appointment?
Oh. No, Judge, I just let all the 11 o'clocks in.
Okay. Mr. McClendon, could you join us for a moment? Were you in city court the night that Mr. Estrada, the gentleman under Motorola, had the tag violation?
Yes, Judge.
You
pointed me to his case briefly, and then Mr. Watson and I had a discussion and figured it would be more proper for a district court case.
Will you take the appointment if I give him back to you?
I guess, Judge.
All right. So you two have already met Mr. Estrada, right? The good news was he got it dismissed for you in city court, but the bad news is for you, it's back in district court. All right. So do you agree, Mr. McClendon, that we ought to just set it for bench trial, or maybe, or do you, what do you want?
We can set it for bench trial, Judge. I'm familiar enough with the case.
Okay. He has filed some pro se motions. Okay, Missy, give me a trial date, please.
We can resolve those motions at trial, Your Honor.
Sure. I just want to let Mr. McClendon know.
How about January 3rd at 11?
January 3rd at 11.
What makes cases like these important isn't the traffic charge itself. It's how quickly small legal situations become credibility problems once someone stops working within the system they're standing inside of. Across these hearings, the courts repeatedly gave the defendants choices: answer the question directly, work through procedure, cooperate with counsel, or bring valid motions at the proper time. But instead of narrowing the dispute, the arguments kept expanding into jurisdiction claims, constitutional misunderstandings, and sovereign citizen theories that courts have already rejected for years. And that creates a serious strategic problem. The moment a judge believes someone is refusing to engage in good faith, the focus can shift away from the original issue and toward courtroom control, compliance, and efficiency. That's why contempt findings, denied motions, and immediate rulings become more likely. Not because the court is avoiding rights, but because procedure only works when both sides agree to participate within the same legal framework. The other pattern here is isolation. Once defendants stop trusting attorneys, court staff, or established legal standards, they often end up representing only their own interpretations. But personal interpretations don't carry authority in court unless they're supported by recognized law and procedure. And by the time someone realizes that, the financial damage, criminal exposure, or credibility loss may already be growing. These hearings show something viewers miss all the time. Most courtroom losses don't happen in one dramatic moment. They build slowly through repeated decisions that make cooperation harder and consequences easier.